The Senate will be in order. I will now call upon the Secretary of the Majority.
Mr. President, I announce the presence of the managers on the part of the House of Representatives to conduct proceedings on behalf of the House concerning the impeachment of G. Thomas Porteous, Jr., Judge of the United States District Court for the Eastern District of Louisiana.
The managers on the part of the House will be received and assigned their seats. The Sergeant-at-Arms will make the proclamation.
Hear ye, hear ye, hear ye. All persons are commanded to keep silent on pain of imprisonment while the House of Representatives is exhibiting to the Senate of the United States articles of impeachment against G. Thomas Porteous, Jr., Judge of the United States District Court for the Eastern District of Louisiana.
The managers on the part of the House will proceed.
Mr. President, the managers on the part of the House of Representatives are here, present and ready to present the articles of impeachment which have been preferred by the House of Representatives against G. Thomas Porteous, Jr., Judge of the United States District Court for the Eastern District of Louisiana. The House adopted the following resolution, which, with the permission of the President of the Senate, I will read. H-Res 1165 in the U.S. House of Representatives, U.S., March 11, 2010. Resolved that Mr. Schiff, Ms. O'Loughlin of California, Mr. Johnson of Georgia, Mr. Goodlatte, and Mr. Sensenbrenner are appointed managers on the part of the House to conduct the trial of the impeachment of G. Thomas Porteous, Jr., a judge for the United States District Court for the Eastern District of Louisiana, that a message be sent to the Senate to inform the Senate of these appointments, and that the managers on the part of the House may exhibit the articles of impeachment to the Senate and take all other actions necessary in connection with preparation for and conduct of the trial, which may include the following. 1. Employing legal, clerical, and other necessary assistance and incurring such other expenses as may be necessary to be paid from amounts available to the Committee on the Judiciary under House Resolution 15, 111th Congress, agreed to January 13, 2009, or any other applicable expense resolution on vouchers approved by the Chairman of the Committee on the Judiciary. 2. Sending for persons and papers and filing with the Secretary of the Senate on the part of the House of Representatives any subsequent pleadings which they may consider necessary. Speaker of the House of Representatives. With the permission of the Senate, the President of the Senate, I will now read the articles of impeachment. H-Res 1031 in the House of Representatives, U.S., March 11, 2010. Impeaching G. Thomas Porteous, Jr., a judge of the United States District Court for the Eastern District of Louisiana, for high crimes and misdemeanors. Resolved that G. Thomas Porteous, Jr., a judge of the United States District Court for the Eastern District of Louisiana, is impeached for high crimes and misdemeanors, and that the following articles of impeachment be exhibited to the Senate. Articles of impeachment exhibited by the House of Representatives of the United States of America in the name of itself and all the people of the United States of America against G. Thomas Porteous, Jr., a judge in the United States District Court for the Eastern District of Louisiana, in maintenance and support of its impeachment against him for high crimes and misdemeanors. Article 1. G. Thomas Porteous, Jr., while a federal judge of the United States District Court for the Eastern District of Louisiana, engaged in a pattern of conduct that is incompatible with the trust and confidence placed in him as a federal judge as follows. Judge Porteous, while presiding as a U.S. District Judge in the Lifemark Hospitals of Louisiana, Inc. versus Liljeburg Enterprises, denied a motion to recuse himself from the case, despite the fact that he had a corrupt financial relationship with the law firm of Amato and Creeley, P.C., which had entered the case to represent Liljeburg. In denying the motion to recuse, and in contravention of clear canons of judicial ethics, Judge Porteous failed to disclose that beginning in or about the late 1980s, while he was a state court judge in the 24th Judicial District Court in the state of Louisiana, he engaged in a corrupt scheme with attorneys Jacob Amato, Jr. and Robert Creeley, whereby Judge Porteous appointed Amato's law partner as a curator in hundreds of cases and thereafter requested and received and accepted from Amato and Creeley a portion of the curatorship fees which had been paid to the firm. During the period of this scheme, the fees received by Amato and Creeley amounted to approximately $40,000, and the amounts paid by Amato and Creeley to Judge Porteous amounted to approximately $20,000. Judge Porteous also made intentionally misleading statements at the recusal hearing intended to minimize the extent of his personal relationship with the two attorneys. In so doing, and in failing to disclose to Lifemark and its counsel the true circumstances of his relationship with the Amato and Creeley law firm, Judge Porteous deprived the Fifth Circuit Court of Appeals of critical information for its review of a petition for writ of mandamus, which sought to overrule Judge Porteous's denial of the recusal motion. His conduct deprived the parties and the public of the right to the honest services of his office. Judge Porteous also engaged in corrupt conduct after the Lifemark versus Liljeburg bench trial, and while he had the case under advisement, in that he solicited and accepted things of value from both Amato and his law partner Creeley, including a payment of thousands of dollars in cash. Thereafter, and without disclosing his corrupt relationship with the attorneys of Amato and Creeley PLC or his receipt from them of cash and other things of value, Judge Porteous ruled in favor of their client, Liljeburg. By virtue of this corrupt relationship and his conduct as a federal judge, Judge Porteous brought his court into scandal and disrepute, prejudiced public respect for and confidence in the federal judiciary, and demonstrated that he is unfit for the office of federal judge. Wherefore, Judge G. Thomas Porteous, Jr. is guilty of high crimes and misdemeanors and should be removed from office. Article 2. G. Thomas Porteous, Jr. engaged in a long-standing pattern of corrupt conduct that demonstrates his unfitness to serve as United States District Court judge. That conduct included the following. Beginning in or about the late 1980s, while he was a state court judge in the 24th Judicial District Court in the state of Louisiana, and continuing while he was a federal judge in the United States District Court for the Eastern District of Louisiana, Judge Porteous engaged in a corrupt relationship with bail bondsman Louis M. Marcotte III and his sister Lori Marcotte. As a part of this corrupt relationship, Judge Porteous solicited and accepted numerous things of value, including meals, trips, home repairs, and car repairs for his personal use and benefit, while at the same time taking official actions that benefited the Marcottes. These official actions by Judge Porteous included, while on the state bench, setting, reducing, and splitting bonds as requested by the Marcottes, and improperly setting aside or expunging felony convictions for two Marcotte employees, in one case after Judge Porteous had been confirmed by the Senate, but before being sworn in as a federal judge. In addition, both while on the state bench and on the federal bench, Judge Porteous used the power and prestige of his office to assist the Marcottes in forming relationships with state judicial officers and individuals important to the Marcotte's business. As Judge Porteous well knew and understood, Louis Marcotte also made false statements to the Federal Bureau of Investigation in an effort to assist Judge Porteous in being appointed to the federal bench. Accordingly, Judge G. Thomas Porteous, Jr. has engaged in conduct so utterly lacking in honesty and integrity that he is guilty of high crimes and misdemeanors and is unfit to hold the office of federal judge and should be removed from office. Article 3. Beginning in or about March 2001, continuing through about July 2004, while a federal judge in the United States District Court for the Eastern District of Louisiana, G. Thomas Porteous, Jr. engaged in a pattern of conduct inconsistent with the trust and confidence placed in him as a federal judge by knowingly and intentionally making material false statements and representations under penalty of perjury related to his personal bankruptcy filing, and by repeatedly violating a court order in his bankruptcy case. Judge Porteous did so by number one, using a false name and a post office box address to conceal his identity as a debtor in the case. Number two, concealing assets. Number three, concealing preferential payments to certain creditors. Number four, concealing gambling losses and other gambling debts. And number five, incurring new debts while the case was pending in violation of the bankruptcy court's order. In doing so, Judge Porteous brought his court into scandal and disrepute, prejudiced public respect for and confidence in the federal judiciary, and demonstrated that he is unfit for the office of federal judge. Wherefore, Judge G. Thomas Porteous, Jr. is guilty of high crimes and misdemeanors and should be removed from office. Article 4. In 1994, in connection with his nomination to be a judge of the United States District Court for the Eastern District of Louisiana, G. Thomas Porteous, Jr. knowingly made material false statements about his past to both the United States Senate and to the Federal Bureau of Investigation in order to obtain the office of the United States District Court Judge. These false statements included the following. Number one, on his supplemental SF-86, Judge Porteous was asked if there was anything in his personal life that could be used by someone to coerce or blackmail him, or if there was anything in his life that could cause embarrassment to Judge Porteous or the President if publicly known. Judge Porteous answered no to this question and signed the form under a warning that a false statement was punishable by law. Number two, during his background check, Judge Porteous falsely told the Federal Bureau of Investigation on two separate occasions that he was not concealing any activity or conduct that could be used to influence, pressure, coerce, or compromise him in any way, or that would impact negatively on his character, reputation, judgment, or discretion. Number three, on the Senate Judiciary Committee's questionnaire for judicial nominees, Judge Porteous was asked whether any unfavorable information existed that could affect his nomination. Judge Porteous answered that, to the best of his knowledge, he did not know of any unfavorable information that could affect his nomination. Judge Porteous signed that questionnaire by swearing that the information provided in his statement is, to the best of my knowledge, true and accurate. However, in truth and in fact, as Judge Porteous then well knew, each of these answers was materially false because Judge Porteous had engaged in a corrupt relationship with the law firm of Amato and Creeley, whereby Judge Porteous appointed Creeley as a curator in hundreds of cases and thereafter requested and accepted from Amato and Creeley a portion of the curatorship fees which had been paid to the firm, and also engaged in a corrupt relationship with Lewis and Lori Marcotte, whereby Judge Porteous listed and accepted numerous things of value, including meals, trips, home repairs, and car repairs for his personal use and benefit, while at the same time taking official actions that benefited the Marcottes. As Judge Porteous well knew and understood, Lewis Marcotte also made false statements to the Federal Bureau of Investigation in an effort to assist Judge Porteous in being appointed to the federal bench. Judge Porteous' failure to disclose these corrupt relationships deprived the United States Senate and the public of information that would have had a material impact on his confirmation. Wherefore, Judge G. Thomas Porteous, Jr. is guilty of high crimes and misdemeanors and should be removed from office. Speaker of the House of Representatives. Mr. President, the House of Representatives, by protestation, saving to themselves the liberty of exhibiting at any time hereafter any further articles of accusation or impeachment against the said G. Thomas Porteous, Jr., Judge of the United States District Court for the Eastern District of Louisiana, and also of replying to his answers which he shall make unto the articles preferred against him, and of offering proof to the same in every part thereof, and to all and every other article of accusation or impeachment which shall be exhibited by them as the case shall require, do demand that the said G. Thomas Porteous, Jr. may be put to answer the misdemeanors in office which have been charged against him in the articles which have been exhibited to the Senate, and that such proceedings, examinations, trials, and judgments may be thereupon had and given as may be agreeable to law and justice. Mr. President, the managers on the part of the House of Representatives, by the adoption of the Articles of Impeachment, which have just been read to the Senate, do now demand that the Senate take order for the appearance of the said G. Thomas Porteous, Jr. to answer said impeachment, and do now demand his conviction and appropriate judgment thereon.
Majority Leader.